Hello and good afternoon, and welcome to our first panel discussion for this afternoon. Our third panel of today is called Open Legal Data and an International Comparison. And it is chaired by Dr. Drago Indjic, and Drago is a co-editor of mine of the Legal Tech book. And so I'm very happy to hand over to Drago in a second. I first wanted to give you a little bit of background on Drago, because he's an expert in legal tech. He teaches legal tech as well. He's also the managing director of Oxquant and an honorary lecturer at the UCL FinTech Institute. And Drago has co-founded several tech businesses. So Drago is an entrepreneur as well across Europe. And he also started teaching both fintech and legal tech at leading business schools, and worked many years, more than 25 years in financial services, also in a large hedge fund for many years. And as I said before, he's my co-editor of the Legal Tech book. So I'm delighted to have Drago here, this very important panel today. And I hand over now to Drago to introduce his esteemed panel members.
Thank you, Suzanne. Well, it is a privilege to chair this session, and back in 2019, when Susanna brought us together, I found myself sitting next to two lawyers, Sophie and Akber, and I was the only techie guy. I'm coming from fintech domain. Legal tech is an acquired taste, and my contribution was really small in this big legal tech pie chart. I carved out a space for blockchain, smart contracts, and something else that it was probably forward-looking. I wanted to have a little slice of something that I would call digital identity and the legal data. And looking back now, 2021, it was a great bet. So today, I'm joined by, if I go now anti-clock counterwise, by Alexis, who is a proper legal tech co-founder lady. Then Charlotte, who is a real tech lawyer. And I have Mike, who is a leading expert on data semantics and all things data related. And my fellow panelists, I feel that people in previous panels and my fellow co-editors did a lot of preparatory work for our panel. I will remind the audience and ask that in panel one, Akber and his guests started discussing data, which is our thing, basically. Data on that could include not just data itself, but data on concepts, on things, data inside contracts, which is a great starting point for our own panel. So just to get immediately this conversation going for today, and asking audience to start asking questions, putting all these icons and little emotions, I would start asking, why not? Why not? Because this is data. Mike, how does this domain that would call for expertise, very deep expertise on data and data modeling and meaning of data, would look like from a perspective of someone who is not really a legal tech guy, but who has been looking for many years on everything data related. And Mike's answer about data then can be a little merry-go-round, where Alexis can get back with a contractual perspective, and Charlotte can put this all together as a practitioner. So Mike, over to you. You are a data guy. You have been forever.
Yeah. Well, thank you. You keep saying we're a data guy, and when I'm with data guys, I sort of resist that and say, well, I'm the meaning guy, and then I baffle them with stuff. But the fundamental thing is what one of the panelists said earlier this morning about the need for a kind of a business level language. So the background there, I kept hearing references to lawyers writing code, and I'm not sure which terrifies me more, lawyers writing code or coders doing law. It shouldn't be necessary. You know, what we're missing, and I think what's been missing in a lot of IT for the last 20 odd years, is an understanding of how IT is managed at the business level. So that's the business oversight of, so like any other engineering discipline, electronics, mechanical, the business says what it is they want, what they're paying for, how they're going to measure it, what they want you to do. Off you go and do it. And we have that to some extent with IT, with the program behavior, with what we call use cases. So we have, like, example, people doing things with the system and how they want to interact with them. When it comes to data, we don't think about that so much. And that's really meaning. Business meaning is a business thing. What does the business mean by this thing? And how does the business own that and own the overall development life cycle of any data or system or application? Now, it's great, you've got this bottom-up agile stuff. It's great for innovation. It's been great for blockchain and smart contracts and so on to get the ball rolling. But even now, we're running up against this problem that, oh, I've got all these different smart contracts and they can't talk to each other, or I don't know if they can talk to each other. I don't know what language they all speak, whether this person's idea of a commitment can be translated into that other contract's idea of a commitment or of the same payment or something else, because we haven't got a common language. So it really needs lawyers not to write code and coders not to do law, but lawyers to understand how to specify at a business level the meaning of what's going to go in the code and what are the management oversight, the engineering discipline in the oldest sense of that word, to be in control of that stuff, not trying to write it, whatever you do. Anyway, that was my reaction to this morning's panel.
Thank you, Mike. Now, because you mentioned language, common language, it's a great point to bring Alexis in the spot, because she's the one who is actually trying to define one of these languages, and the previous panelists left one important question unaddressed, which is, what kind of language are we going to use to describe these contracts and legal tech, etc.? Alexis, welcome to Singapore. It's very late. You're still
no worries. It's 9, so my day's my evening's just getting started. Can anyone hear me okay? You can hear me okay? So I think a few points. Well, I'm not technical in the sense that I know how to program. I'm a self-taught programmer, but I'm not a computer scientist. I'm legally trained. I gave up big law a couple of years ago, and went to the deep end, joined the dark side, and co-founded a company with my co-founder called Legalese. And right now, Legalese is partnering with the Singapore Management University, where we run a center for computational law. And I'm giving a little bit of background so you can have some context about what I think about data and what we think legal tech needs. So I also teach a course on computational law and legal technology at the university. And I'm industry director at the research center as well. So the research center is basically where we park all the open source research that our startups got to do, and quite handily, the Singapore government gave us 15 million to do that. So that's money I don't have to raise myself. So that's always good. But the reason why we decided to go to university, to go to government, to get a lot of funding to do that was because we realized that law, like you said, didn't have a common language, and that's an infrastructural problem where, you have people building intermediate, middle level or end level user facing applications, and they're quite proprietary, they're quite standalone. And sometimes you don't want to onboard yourself to that, because what if that startup dies? Then where does your data go? What happens to all the effort spent onboarding yourself onto an application? And also, they don't talk to each other because they don't belong to the same infrastructure. They may belong to the same ecosystem, which is legal tech, but they don't have a way of speaking to each other in a way that makes sense. So the way we thought about it was, other professional domains, whether it is graphic design or whether it is architecture or even accounting, they were they're still professional domains, but they have software that augments the way they work. They use computers and technology to help with the thinking and not just manual labor. But law, despite being a professional domain, we're very proud of how clever we are and how good our grades were in school. And so we're not really using technology to help with the thinking. We use it to help with the typing, which is, a bit awkward in this sort of software-driven world. So the way we thought about it was, look at accounting, look at graphic design, look at architecture. They have Autodesk, they have Adobe, they have spreadsheets, or they have Intuit accounting if you're in the US. And all of these software are the kind of software where you say, you wouldn't be a very good graphic designer or photographer if you didn't know how to use Adobe Photoshop or InDesign, or you wouldn't be a very good accountant if you didn't know how to use spreadsheets. And it's nothing to do with how good your math is or how good you're good at drawing. But lawyers don't have that. And the way these software started was not by starting with the software. Adobe's first app wasn't InDesign or Photoshop. Adobe's first app wasn't an app, it was a language. It was PostScript that allowed you computers and printers to talk to each other in a sort of common way. And that was the same case, whether it's a spreadsheet, same case with Intuit, same case with architectural designs with DWG that Autodesk invented. And the same thing for databases, for SQL or SQL, wherever you're from. And so we thought law doesn't have that, because law is one of the oldest, professions in the world, and law predates almost everything in the world. So how do we get to that how do we get to a future where it is technology enabled and it is plugged into technology without sort of spending your whole time sort of reverse engineering and sort of playing catch up, because law is already playing catch up without even talking about technology. So our idea at our startup and at the university was to create a domain specific language for law. And, obviously it is a programming language, but this will be the foundational infrastructure that allows you to build up allows you to write data in, it allows you to build applications in, you can compile to different applications, you can compile to different application languages, so you can compile to natural language or programming languages, and so this is the foundational layer where sort of we think the infrastructure of law begins, because otherwise everyone's just speaking at cross purposes and sort of reinventing the wheel all the time. So if we have the infrastructure with a language, an open source language as the foundation, then you can build apps in between. You can have things that are sort of low code platform or no code platforms, and you can have at the top of the layer something that the end users use. I like to call it the Instagramification of law, where I don't have to learn how to use know anything about focal lengths or aperture to know that if I use a filter in a certain way I'll look prettier or whatever it is. And you want the same thing to do with law, because no one actually needs to have to go to law school to be able to receive legal products or legal services, and that's a sort of huge disservice to end users and consumers. So I think our approach, and we call it computational law, is that you want to first build the infrastructure as the foundation before you can build anything else, because otherwise it's a lot of wasted effort. So sorry, I took a lot of time, so I've stopped.
That's fine, Alexis, because now the scene is completely set up, because we have someone like Mike, who is in charge of data quality and meaning of data. So data is sorted out. If you don't trust your data, you don't understand what does it mean, go to Mike. And we have you, with his Rosetta Stone and legal language, etc. But then, hey, we've got people, right? And now Charlotte is going to sort out the rest. And the rest is actually very human, because actually it's people who are entering contracts. Because when I have a protocol, it's machine-to-machine thing. I don't need internet Cisco router to consult me to route some packets all over the place. I don't need anyone to run something on blockchain. It's a protocol. It's sorted out. It's really code is law. I can't argue with the blockchain or packet routing. But fortunately for humans, for users of legal tech, we have humans who would like to own things. And we have humans who would like to be private, who decide what can be open sourced or not. And that is why we've got Charlotte. Charlotte, please tell us, what do we do with these languages and data?
Yeah, exactly. It's super interesting listening to Alexis, and I 100% agree that I think there's a lot of things that the legal profession can do, and not just necessarily the legal profession, but also regulators, courts, legislators, and so on, to kind of get to an aligned standard. I mean, a lot of the companies that we work for are really international startups or multinationals who are actually now supplying products globally. So the thought of having kind of jurisdictional issues with borders, for example, becomes really difficult when you're trying to work on a global scale. Then obviously you have kind of like international overarching pieces of legislation like the GDPR that tries to apply across Europe and then to anyone else that's providing services towards Europe. But I think the point that Alexis raised about, legal language and trying to find a common legal language is like one of the key issues in law. I think we all love as lawyers to consider ourselves as being like amazing wordsmiths. And if you look at the amount of effort that goes into definitions in legislation itself from one country to another, and then even just the negotiations that we can have in contracts, for example, working out a certain definition that's going to apply. I think that that's always one of the problems and issues that comes up. And I think if we can have a kind of common goal and a common language, which is going to just kind of facilitate, I suppose, kind of getting to a stage where we can really apply legal tech across the board, necessarily without borders to an extent, because that's the way the world is truly a global community now. And I think that comes back to the point that you said, how do we kind of work about balancing this? I think like the legal profession obviously can be deemed to be quite elitist, especially in some countries. For example, I'm a lawyer in France and also in the UK, and it's really interesting to see the different approaches. You know, I think for years now, the kind of legal profession in the UK has become less regulated with the Legal Services Act, for example. There are certain reserved activities, and it might be right then to have, you know, an admitted barred professional dealing with those questions. And then on the flip side, you have France, which remains extremely regulated. And I think that everyone here really needs to work together to look at the kind of common goal and the overarching sort of aim that needs to be achieved. I think there's a lot of reticence to kind of accept legal tech, as it were, because law is deemed to be so important from a justice, social, economic kind of perspective. And then it comes down to, like, how do we go about balancing this? And you're completely right. I think until we have a common goal, you know, what is the goal of legal tech? Do we want to get to a stage where there's literally no human intervention now and everything can be automated and there's no need for lawyers? Or do we want to get to a stage where it's kind of like a middle ground? You know, I think we need to look at the beneficiary of the legal tech. You know, for example, having an automated dispute resolution for things like delayed flights and kind of compensation. I think eBay and Amazon have really great online dispute resolution portals for basic matters. But then on the flip side, you know, if you're facing a prison sentence, for example, for a crime that you didn't commit, I think in that case, you know, that's obviously two extremes, but, you know, you're probably looking at wanting to have some sort of human intervention, because I think you can't always take the beneficiaries out, you know, the human aspect out of the chain completely. But I think it's really important to be able to combine both. And just coming back to one of the points that you raised about, you know, so how does this work? How can we go about balancing out privacy rights, big data, access to data? Because obviously to kind of improve the machine learning and the processes that Mike and Alexis are working with on a day-to-day basis. I'm not a coder, I'm not a technician. I just work a lot with startups in a kind of innovative field, and so come across these type of issues actually that come up day to day. The aim is to be able to get there, to drive the digital economy forwards. And sometimes it does seem that the law is quite behind in that sense, but it is also, you know, balancing up quite important individual rights and freedoms, you know, balancing out ownership of data, like what's the basis that we have to be able to come to these solutions. Then there's the balance of having, you know, a common regulation, because, you know, technicians, coders and the rest of it shouldn't necessarily have to go ahead and make decisions on their own without legislation, for example, governing and ruling how they are doing things. And then when you're looking at a global perspective, that becomes extremely difficult as you're starting to take into account the different approaches, the different importance. Access to data, for example, in China may be very, very different to access to data, for example, in France, the UK or the US. So it really comes down to how we can kind of reconcile all of these competing interests. And I think it does come down to A, the common goal, and B, the common language, so we can go from a starting point. But I think we can't, as you say, take this out of the context that human beings and, you know, consequences for their lives are essentially involved in many kind of legal cases and decision making. So I don't know if you kind of want to go from there. I know we had a couple of survey questions, for example. One of the really, really competing aspects right now, I think many developers have this need to be able to have as much access to data as possible, freely accessible, unfettered. You're thinking of big data with like velocity, value. I think it's the 3 V's that we talk about: variety, volume. I think value is potentially the 4th V, because there is obviously an aspect of monetizing big data, which is a lot what a lot of companies do right now. For example, access to information, access to court decisions. And then on the other side, we have sort of individual rights of, you know, how much do we want to be subject to this kind of open information society, which is potentially needed to actually drive legal tech and innovation in general forwards.
Thank you, thank you. I'm not in a very different time zone, but I'm in a different time zone. I'm in Serbia. If I pick up my phone, it is like 5G, and I know that 5G will work across the globe. But I also know when Mike hears something like common language, he will get very, very excited. And that is my worry these days. If I double click on one of these legal tech apps, and even if it is using Alexis language, Mike, what do you think? Will I actually discover something that is truly open and global or not? Let's start.
I think there's, I think there's some steps we need to go through. So I was reminded by what Alexis was saying about, the different tools that different professionals use, for like, photographic software and so on. But of course, when those things first came along, everybody thought, oh, I can do everything a designer does, or I can do everything a writer does, or I can do everything a photographer does. And of course you can't, but you need those tools for those professionals. And what they do is they abstract away some of what you need to do. So what Charlotte was saying about, that front end stuff like claims processing or, initial stuff. And there's an interesting comment in the chat that if somebody was an indigent defendant in the US with some of the public defenders they might get, they might even choose the robots. That was an interesting comment there. But I think there's a parallel there with what's been happening in industry and, Internet of Things and automotive and so on, where, you have lots of devices. So you put some AI in front of it and say, well, let's use AI to do the high volume, low quality stuff, and then spit out the difficult stuff at the back for the real intelligent machines and then humans to deal with. So I wonder if there might be some kind of filtering there. And what that leads to Drago's question is, so for all of that to work, you've got to have a common language. And there's two sides to language. There's nouns and verbs. So in software, there's like, classes and processes or operations, for example. There's what there is and what there does. And those both need to be standardized. And we then think, oh yeah, that's easy. We just get everybody to agree on the words and the words will be fine. But actually, the concepts are what you need. Concepts are framed in logic in some coherent way that is independent of words or language. And that's very hard for some folks to understand, because that brings a whole new discipline into the exercise. And the thing with that is that one of the main important ways in which you frame concepts like that is this idea of something being contextual or contextually relative. Because in order to have something that understands what jurisdiction it's in, that understands that, this contractual clause that works perfectly well in England won't work in Kenya because the statutory law says something else, then, you need a lawyer. This is, I've written my own contracts, but I'm not a lawyer. You need a lawyer not to write those clauses, but to know which ones will be blown up or blown away in a court of law because of applicable statute. So there's going to be lots and lots of contextually specific kinds of definitions and a whole science of how we define things that's got nothing to do with taking words and writing down their meaning. So that's, until we get over that step, we can't create that front end AI kind of stuff to do the easy stuff. I think that's my hunch anyway.
Thank you, Mike. And I guess if we have this language things sorted out, or at least data risks sorted out, let's figure out from Alexis, this language that you're doing, you're not going to take responsibility or liability for the data inside. You're providing a language. So what do we do at this language layer?
I mean, today when there's a data breach, do people hold SQL, the programming language, responsible for, the SQL does not own language written in SQL. Your iPhone applications may be written in Swift, but the developers writing who develop Swift don't own your application. So I think it's important to think sort of to decouple the idea of language as infrastructure and language that you have that you read from the applications. And what I mean is, so you have language, the programming language for law as the infrastructure, and that's sort of foundational layer, and that's that would be an implementation language, and you can output to different programming languages and different natural languages, and that's when the natural languages come in, because when you build applications, you may not build applications in I mean, you may be building applications in JavaScript, but then, and maybe that was 10 years ago. And then you're like, oh, iPhone is, the market leader now. So we're going to build it in Swift, or we're going to build it, or now we want to be compatible with the Ethereum blockchain. We're going to build it in Solidity. And I think an implementation language sort of goes beyond that. So it's a sort of programming language that allows you to build into other languages. So that's one bit. And the second bit is that when you build applications and when you, for example, build an application that allows you to output to natural language. So that's a function that the application does that the language enables, where you can say, I would like to output this contract that is, or this, use case, whether, and for the record, when we say law, we don't just mean contract, we don't just mean regulations, we don't just mean regulations, we mean everything that gets you sort of from one end to the other, so that could include contracts, regulations, statutes, but also business process logic, or even guidances, memos that regulators issue, because these are all the things that a lawyer or someone legally trained will look at when they're answering a question. So when you have an application, once the language is built, so assuming we have the infrastructure, and then you have sort of you open up the field where the legal profession isn't just the legal industry, because today when we talk about the legal industry, we seem to sort of more or less only refer to the legal profession, which is lawyers, but accountants are not the only people making up the accounting industry. Accounting software companies also make up the accounting industry. So I think sort of the first step, I think, is to get us slightly beyond that. And we're not competing with perfect. We're not trying to say we're going to do perfectly, regardless of what everyone's come before. We're trying to do something slightly better, or at least, better than the status quo, which is humans running on billable hours, which, benefits no one except the lawyers. I mean, even then you don't really get your work-life balance, which is why I quit, but still. So I think when you output to natural language, you can say, I would like the code to output to English because my contract is English. When I write a piece of application or I try to answer a problem, the application, let's say it helps me incorporate a company in Singapore, but, my client has decided to incorporate the company in Hong Kong or UK instead. So instead of rewriting everything in sort of from scratch, because you're like, oh, let's figure out what is UK law or Hong Kong law, let's figure out what documents we need to look at again, you sort of first take out the sort of Singapore law of, well, where I'm from, Singapore law. So if you take out the Singapore law library, which is what you do with software today, and you say, let's import a UK library for the relevant statutes instead of rewriting that from scratch, because the sort of the foundations, the data are written in a slightly different layer, and that's open source and that's open. I mean, that's the ideal, where your regulators and your governments make those available to end users. And you take that and you say, okay, let's change that around. And the only things you need to change are the sort of very specific things that you don't have libraries for, or you're trying to build specifically for a function that the new country has that the previous country didn't have. So I think it's quite important to separate the infrastructure layer from the applications it does, because at the end of the day, we're talking, we're kind of jumping between time frames here, right? Because when we talk about building the infrastructure, that takes 3 to 5 years, maybe even 8 years. In fact, the research on this goes as far back as the 1970s. People have been doing this. The British Nationality Act was codified as a logic program in the 1980s. So we've come a very long way, but the work still needs to be done. But I think when we're talking about building infrastructure, and then we're talking about building the applications in the intermediate layer, and then ultimately building something that the end users can do, it's sort of it's different stages of maturity that we have to see the industry going through. But I think the first step is still getting the industry to include not just lawyers, but also other people. And I think, and I like to make the point that the reason why I emphasize this a lot, computational law isn't really going to be built by lawyers, but we can't build it without lawyers. The same way, you can't probably build Uber or Airbnb without someone who's stayed in a hotel before, or someone who knows how to drive. But you're not asking a lawyer or the legal industry to come up with what's going to be the thing that changes legal as an industry, as a profession. Is kind of like going into a taxi 20 years ago and asking your taxi driver, how are you going to build this app that, or something that will, shake up how things are going to be done within your industry? And the example I like to give is that of like a cartographer. If you went to a cartographer 15 years ago and you said, hey, I'm from the future and I've got this really cool thing called an iPhone and I know you're very good at drawing maps and making maps. How about you take this thing and tell me what you're going to build to make map making or map reading or map using super wonderful? And they would probably come up with something pretty good, like Google Earth, where you can say, I don't have to download all my maps. Oh, I don't have to carry all these things around. I can zoom in on all these things, which is cool. But what you really want isn't Google Earth, which is cute. What you want is Google Maps, which requires you to, which gives you functionalities like, how do I get from, at what time should I leave house if I don't want to be late? Which route should I take if I don't want to pay tolls? And those are functionalities that are in the realm of computer science and in the computer domain. So I'm not sure if the lawyer or the cartographer would be the person, would be the person to bring us there. And obviously, I'm not saying that lawyers are not involved. So I think there was one question that was interesting was, I'm very happy with my lawyers converting what I want into legalese. I'm less confident about my lawyer setting up my smart contract, who would like to allay my fears. And I think I agree with you. I wouldn't trust that either. But either ways, I mean, stepping away from smart contract, even just sort of regular contracts that you use software to generate, I'm not sure I would trust a lawyer to set an application up to do it properly because they're not programmers. So I think because it is sort of multidisciplinary, when we build infrastructure, when we build the applications, we need all sides involved, but we do have to recognize that it's probably the computer scientists who are going to be leading the charge on this and not the lawyers. And I'm not saying that the future is a future where everyone has to learn how to code. I mean, no, I don't even think the computer scientists and the programmers will agree with me on this because we've been needing more programmers since the 80s. That was before the era of personal computing. And that, I don't think that's the answer. I think you do need the sort of core infrastructure to be built and to be maintained by professionals like computer scientists, like programmers. But I think the key is that you want to open up the industry where software, where companies, where governments have applications in intermediate and the top layer, intermediate meaning low code, no code platforms, or the top layer where it's user facing applications where I don't need to go to law school to know anything about this. I don't even need to know how to program. I just need to know how to use a phone. So I think that's sort of where I stand on this. Have I?
Correct. Thank you. Now we've got like 20% participation rate, but we've got the poll results. I hope that people can see or we can share that. And Charlotte, I mean, people have mentioned. I think we've just lost connection with them. But this pool, I think we can close pool 1 or at least freeze the pool 1. And it shows with this limited participation that actually more people are interested in privacy than openness of data. And that result of this first poll is exactly what Charlotte can discuss, because on top of these apps, we have a question of consent, intent, and Charlotte, what do you think about the results of this poll that you can just see? So there's wanted privacy.
Yeah, no, exactly. I think it's actually kind of surprising. It's I see that it's slightly changed. When I looked before, it was 60-40. Now it seems that people in this conference right now are actually putting individual privacy rights above everything else, which is kind of interesting, because I imagine that the audience here would be really wanting to push the kind of like furtherance of big tech and innovation. So I mean, obviously 35% of you said that you would feel that freedom of information, access to data is more important, and then 64.7% privacy rights actually at the forefront. And I think this is really interesting, and it kind of comes back to what Mike and Alexis have been saying. I think everything here comes down to a level of balance. Like, I think obviously this is something that we're feeling as individuals ourselves. Quite often startups can actually do things to push innovation forwards. And then I think when you take a step back and look at it as a personal individual, you kind of think, hang on a minute, actually, as an individual person, do I necessarily want to be subject to that? But I think it's really interesting, the comments that Alexis just made about, I don't think that we want to necessarily replace law with tech. We don't want to just live in a situation where we have been to date just relying solely on human lawyers themselves, like, firstly, the profession is exhausting. We work incredibly long hours with incredibly high stakes. I totally understand Alexis kind of stepping away from big law, which is exactly what I did when I founded my own firm. But as soon as everything comes down to relying on humans, which is a problem for any service industry, you know, if you're working in finance, any form of consulting, I'm sure all of our friends at PwC and KPMG will completely agree with us, not necessarily working in law, but when you have that professional services aspect, it necessarily requires humans. Those humans are necessarily well trained and educated. So then you're coming into this structure of differences with kind of fees and hourly rates. And I think, you know, it's really important to say that the future going forwards has to be a combination of both. I think that legal tech solutions can actually assist a lawyer's day-to-day work immensely. It's something that we are already doing in my firm, for example. We're trying to think of ways to not this, but access to legal services just generally. There is always going to be some scenarios where you have a multi-billion-dollar company that doesn't mind paying significant fees because of the value of the matter at stake. But then on the other side, you have startups that are essentially prohibited sometimes from getting adequate legal advice because they just cannot afford to pay for, and it's not interesting to have that very manual day-to-day kind of intellectual input from a lawyer, which can in a lot of cases be automated. So I think it comes down to a balance of the profession, A, wanting to accept these things, and B, the kind of developers of legal tech solutions being aware of that. But I think kind of as we start to go forwards, I had a very interesting conversation with somebody yesterday, and we were talking about how the kind of new generation coming forward is so used to having things available at the touch of a button. You have a problem with your Adidas order, you can jump right onto Facebook chat and make a complaint, and you have a solution within a few seconds. People are now starting to have the kind of same expectation when it comes to professional services too. They often want to be receiving a service which is something like the things that they're having in their private life, you know, use of Instagram, use of social media, use of smartphones, which just becomes completely normal. I mean, I can't even imagine my life without my iPhone. Yeah, when the iPhone first came out, I remember thinking exactly, why do I need a phone that takes pictures and does all of this crazy stuff? You know, and I think that's the same thing with kind of legal tech and the evolution of the legal profession. Like, as the new generation comes through, it's completely natural to want to kind of apply these day-to-day things to our professional lives as well, or for any other services that we might be getting, whether it's related to our businesses or our personal lives. But I think it's really telling with the results of this poll that despite the fact there is a need for this and there is a drive, it's very interesting that the kind of personal individuals between us when looking at things do nonetheless want to kind of have that balance of privacy rights being at the forefront when it comes to kind of access to information and data that would necessarily like underlie these tools. And I think just to kind of add to that, as regards to lawyers learning to code, I mean, it's always the big question, right? Do they need to code? Do we need to do this? I don't think so. I think everyone needs to be expert in what they're expert at. So let's leave that to the developers and the people that are highly skilled. I 100% agree with this, but I do think that we're seeing a lot of changes. I mean, like, the UK is quite forward in this sector. I think there's quite a few sort of larger firms or magic circle firms in London that are now kind of offering like a plan B, not even a plan B, but just a separate track for training contracts. You know, you have the traditional lawyer route, and then you have the kind of legal technologist route where you're still training as a lawyer and becoming ultimately a solicitor, but you're having a focus on the new way of doing things. And many of the large firms now are starting to open up legal technologist departments where you actually have these stakeholders involved who drive these type of projects forward. And I think, again, coming back to the human element, lawyers are human too. Partners that have been working as they are for the last 30 years may be reticent to change, but I think in order to survive, you have to be able to adapt and respond to kind of the new generation of services that are coming through, and just to make sure that law is essentially aligned to everything else we have, like, you know, finance. I know we spoke before, Mike, about, you know, things like Monzo and Revolut. This is becoming so normal now and is completely recognized fintech. So I mean, I think that legal tech has to kind of go in the same direction, essentially.
I'm intrigued. Yeah, sorry, go
Yeah,
ahead.
go ahead, Mike, because I guess you will be able to immediately address the very first question that we've got, which is on the top about cross-jurisdiction, different languages, etc. Because it is exactly this hope of open banking being translated into open legal something and this interoperability. That is a question for you. Yes, go ahead, Mike.
Yeah, let me circle back to that because we touched on that earlier. But I was intrigued by Charlotte's point about the current generation being expecting everything at the push of a button. Well, I'm old enough to remember when you could turn things off. I think we've actually got conditioned to being less in control of things than we used to be. When you just did a thing and it was let's stay where you put it, and you turned it on and you turned it off, and it did what you wanted it to do. And we've conditioned a whole generation to get used to a lot of nonsense the software throws at you, and it comes back to this sort of steady deterioration in that software quality and process. The layers of the application that Alexis describes should be reflected in layers of people doing stuff. And we have exactly the same thing in finance. We said, okay, we need to get the meanings of what's in the data, so let's get the subject matter experts over here and the semantic techies over here. And the semantic techies, like any other techie, they want a use case, they want instructions, they want to never be wrong because they're doing exactly what they were told. And so they create these use case driven ontology artifacts, and they're not very good because what's missing in the middle is another discipline, the ability to abstract, the ability to think logically about meaning and concepts. And it's a kind of applied philosophy. It's effectively library science. A large amount of it comes from the ancient Greeks and Middle Ages folks. Another large part comes from a chap in India in the 1940s that invented the whole classification theory. You need to recruit people like that who are probably not good at tech and not good at whatever your subject matter is, but are able to deal with that kind of abstraction. Because the kind of challenge we're seeing now, we saw it in finance with payment. You've got these very smart techies creating this wonderful digital currency that everybody will be using to pay for their Tesla. Well, guess what? They're not going to be using it to pay for their Tesla. But hiding behind all that slightly misplaced stuff has been some incredibly valuable technology for buying and selling microdata on the Internet of Things and creating digital currencies that are backed by some kind of fiat or something real. And the value isn't necessarily where you expect it, but you need the sort of bottom-up anarchic techies to go in and create the sort of the ground-up stuff to begin with. But what emerges, these abstractions, these opportunities, these business opportunities are often quite unexpected, but they require that different level of thinking about the meaning, the principles, the concepts, the principles enshrined in laws. Data protection, that poll we just had, Richard complained that the two questions were a little too exclusive, or probably got the wrong word there, but there's a middle option there, which is I want to be in control of my data. I want to tell somebody to give this account number from this provider to that provider, and I don't want them to turn around and say, I can't do that because of data protection. No, data protection says I'm in charge of my data, and if I tell you to put that data from there to there, you do it. And how many people have understood that abstraction, even at the level of the regulators and the lawmakers, let alone the implementers of systems, to allow us to imaginatively understand the business opportunities, the abstractions, the legal and regulatory requirements and the principles that those represent, and enshrine those in the software and the interfaces and the applications that we build. So that was just my kind of reflections on that.
That's a brilliant reflection, because it is inviting all sorts of questions, going back to the very first question about interoperability. But you see, Alexis, the question that we've got in Q&A is a question of legal polysemy, and it may be related to the fact that taxation and, jail sentences for the very same offense will be very different across different jurisdictions, which is almost like inviting the question, what do we do to help Legalese go global, to scale up, to run perfectly well in Peru, in Bolivia, in Serbia, in a few other countries? Do you have any ideas? How do we go about Legalese.
Oh, absolutely. Although I must say that Legalese isn't the only one. I mean, there's probably like 5 people in the world who believe in the sort of same approach as we do, but we just go about it quite slightly differently. So there's like people like Legalese, who is working with the Singapore Management University, working on the domain specific language for law. There's people like Clause, I think they're based in the US. There's also the sort of Dion Digital project in Copenhagen. There's the FCL project in McMaster's, and there's also the Cardano project and a bunch of other sort of core project blockchain type things that sort of are in parallel to what we do, and we overlap quite a lot. So so yes, but I would like sort of not just Legalese, but not just the language that we built, but also we need the language to, and that's why the first step is to making sure that the language that anyone contributes to is open source, because if you end up as a closed source language, then you can't even get the existing techies contributing to it or using it or forking it to figure out if it's something that is fit for purpose or that's something that they can sort of fiddle with to make it fit for purpose. So I think that's the first step. The second step, I think, which sort of Mike touched on, which I think is quite a valid point, is that you don't just want the programmers and you don't just want the lawyers, and the layer of abstraction is this very high sort of logical thinking, and that's actually one of the areas that that we hire for at the Center for Computational Law, which is again the branch where we work on the open source AI and open source research in Singapore. And that's a branch of sort of deep tech computer science that we call symbolic AI or symbolic logic, that allows you to say, and sorry, before I go into what that means, is that we distinguish ourselves from sort of statistical methods. We recognize that statistical AI is great, you know, big data, neural nets, all of that, machine learning is great for some things. But like you said, you know, for things like sentencing, it's not great because you don't want to entrench the existing biases and problems that we have into a computer program that we can't really understand and hope that, you know, fingers crossed, it will, well, tell us exactly, you know, give us an answer that will be aligned with exactly what has been happening before, and that's not great. So I think what we want to do is sort of the way we do symbolic AI, which is instead of saying that we're going to work off data and build something off data and of existing cases, which is, you know, admittedly what common law is based on, we're going to work with sort of logic from first principles and say that, you know, you want an AI that you can argue with. You don't want an AI that says, hey, you know, all your friends jumped off a bridge. Do you want to jump off? And they'll say, oh yeah, all my friends jumped off a bridge. Yeah, I'm on. You kind of want an AI that says, you know what, I've been optimized, I've been written to sort of think about first principles, and the first principle I've been optimized for is not dying. So the fact that all my friends have jumped off a bridge is not relevant, and I will not do that because they all died and I don't have any more friends, but I'd like to stay here. Thank you very much. And I think that's the kind of AI that we're working on. And I mean, I know that's the kind of AI we're working on. And that's not to say there's no place for statistical AI, but symbolic AI allows you to have AI that you can reason with, that you can argue with. If something isn't quite right, you know, you can say, you know, go back to the logic. What principles that we affirm? And this doesn't have to be universal, because countries and jurisdictions and organizations are not universal that way. You can say, you know, I choose to optimize for this group of people not dying or having fewer losses, as opposed to this other group of people who are very well off already. And these, I mean, it allows you to see and sort of not sort of abdicate responsibility for what kind of principles you as a jurisdiction, organization, infrastructure, country want to affirm, and sort of you can hold them more accountable than you can already, because people will always, you know, I mean, in fact, even in litigation, you know, you don't really go to a lawyer and say, do I have a case? You say, I want my money back. Well, I was a litigator. So, you know, you say, I want my money back, make it happen. And then your lawyer goes and looks at everything and says, okay, I think I know, let me tell you what I think happened. And you say, yes. This will get me my money back. You're like, probably. But, you know, that's how it works in the real world. So, but, you know, again, we're not fighting. We're not trying to build something perfect. We're just trying to avoid the situation where, your entire infrastructure is built off humans, and the only way you can get sort of assurance is to go to the priesthood, who are lawyers, who are insured, who say, oh, I'll give you my blessing, doesn't matter if you know it at all, just go do, and if anything happens, you sue the other side because it's easier to sue the other side. You kind of want something to say, you know, well, you can see what logic or what principles it's affirming and what it's built off. And you can still sue the software company, you can still sue the lawyer if you want to, but at least you sort of at the outset, litigation isn't your options aren't litigation or priesthood or blessing. It is litigation, priesthood, or also like I can assess for myself an intermediate level and helps me get sort of an intermediate sort of solutions in a way, because you have that layer that is being made visible for you as an user, because it's something an application can do for you. And I think Richard made a really good point, was that before we just take a step back again, just without talking the big picture stuff, we need to see what computers are really good at. And, things like calculating things. And we're not even using computers to do that in law. We're using lawyers who like to tell you, oh, we became a lawyer and we didn't go to med school, or we didn't go do an MBA because, well, I wasn't very good at math in school. And that's cute. But, no, I'm paying you $800 an hour. I'm not willing for you, I'm not okay for you to do that. So we need to start thinking about first infrastructure, but also what kind of things can you decouple, where you can say these are kind of things that computers can do really well. And these are the kind of things that, well, lawyers do better than computers now. But what if we start building things with lawyers so that computers can do it as well as lawyers? Because again, relying on lawyers means that, you might get lucky because they've had their coffee for the day, or you might not get lucky because, someone just passed away. So I think that's not, I think that's something to sort of bear in mind.
Thank you. That is brilliant, which with the idea about this definition by Richard Susskind, that the legal tech is something to deliver law when a lawyer is not available, kind of offline or in your device, etc. But Charlotte, this is going back to humans like, because you're handling real people, real companies, real contracts. You're not just a techie. And would you like to comment on that? Where is this human element or the final client coming into this picture? And I guess we can run a second poll, if James can run the poll about size of legal data industry. So I would let you handle my question, and hopefully pool will come through. Please.
Yeah, no, definitely. I completely agree with everything both Mike and Alexis have said, actually. I think it does come down to a huge risk when you have humans involved in anything. Like, just by our nature, we are imperfect. We cannot be accurate. We cannot be amazing. We cannot be 100% at the top of our game all the time. Like, the very nature of who we are means that, errors are made. Again, by using kind of tech solutions, the risk of error then can be drastically reduced, because in theory, once it's been programmed and programmed correctly, then at that point, I guess, we're reducing any kind of margin of error. I think the problem also arises then when you're having humans that are then ultimately creating the initial kind of technological solution, because, then that human could make an error. We've all heard about things like the predictive justice sort of matters. I think, for example, AWS and possibly Microsoft was saying that they wouldn't roll out things in relation to facial recognition technology with various police forces across the US until they could actually understand how the humans were then planning to use those solutions. So I think it works on both sides. You kind of have the lawyers on one side who are humans at the end of the day providing services, and then you have the humans as the client, i.e. the beneficiary of those type of services. And I think there is no perfect solution, and I don't think there should be a steadfast, set in stone solution at all. I think the whole point here is that things evolve. Obviously society in itself has changed massively, even in the last kind of 20 or 30 years, with the things that we now have access to and things that are available. If I just think of my parents' generation, they grew up in a very, very different period. And then just in a lifetime away, now we are ordinarily able to travel really freely around the globe. We have access to information in a few seconds. And I just think it's really important that any solutions that we come to are kind of taking this evolution of just humankind into account. At the moment, we're kind of on this plan, I suppose, to try and reach Mars. Previously, back in the 60s, the whole point was, to land on the moon. And then prior to that, I think it was just about having the first human flight at all. So if you think in that short space of time, like how much that has projected, it's an example of how kind of humanity and our expectations kind of change and evolve. So I think it does need to be really flexible. At the same time, it is really important to ensure that, you know, rights and freedoms are kind of, you know, respected and implemented. I think that's always one of the issues. I think one of the questions was talking about kind of cross-border collaboration and, you know, how can this work? It just seems completely impossible to get really fully aligned on these processes. So if you look at things like, you know, legislative initiatives just across Europe, you know, this is just a small number of states when you compare that to a global scale and the number of years sometimes it can take to come to a conclusion on something. The same with just national legislative propositions. So I think it's really important to kind of keep that flexibility in mind and that level of evolution, but also bearing in mind that, you know, ultimately when you're talking about legal matters, there are serious things at stake. It's not the same as just being able to play a game on Facebook or on an app, or just kind of click a few likes on some photos on Instagram. Like, there can be quite significant things at stake. And I know when we were preparing for this panel, we had a bit of a chat about things. And, you know, we were talking about how, for example, I think the European Commission's trying to kind of implement some sort of AI regulation right now. There was a draft proposal that was leaked, which I think has now been officially kind of published as a draft. And it just seems very difficult to try to start regulating something which ultimately is not fully defined and is constantly a moving target. And the legal tech book, which I was a co-author with, which Drago was heavily implicated in, you know, we talk about, can the law keep up with the development of AI? You know, that's one of the big questions. And should it? Because it has so many different elements to take into account. It's very easy for developers to be like, let's go to this solution. And we all know that tech stuff can take ages and be stuck in development, and sometimes stuff takes longer than we think. But, you know, then you get to a scenario, for example, like with the GDPR, which was so many years in discussions, it then comes into force and all of a sudden we have this amazing solution, but we're not quite sure what problem it's going to solve yet. But we have blockchain. But one of the big issues with that is the point of blockchain is nothing can ever be deleted, which goes into direct conflict with the right to be forgotten for GDPR purposes. So it's just very, very hard for the two to match up. So I think it kind of comes into this sort of realm of having kind of flexible code of conduct and maybe soft regulation and industry standards per sector, and maybe even per jurisdiction, where some countries are going to be taking things at a level of importance. You know, we just have to talk about things in relation to national security, for example. All of the issues, I think we've just seen Microsoft, who've now announced they're going to like relocate servers to the EU to kind of get over that risk that American law enforcement authorities can have access to European individuals' data. You know, the US will ensure that national security trumps everything, even individual privacy rights. But Europe, that's not the case. So I think we're always going to have these kind of like local variants depending on where people are based and depending on the kind of temperature of just the individuals and the society that is kind of dealing with these sorts of technologies. And I think just to come to like the poll that James has really helpfully input there, it's super interesting because, you know, whilst we're talking about access to justice, access to legal services, facilitation, and just kind of making life easier for end users, like, you know, you shouldn't be flabbergasted or shocked or completely unable to understand what your lawyer's advising you or what the consequences are of various legal situations. Like, I totally agree, it should be kind of user-friendly and really intuitive. But obviously this does come down to kind of an economy because, you know, whilst we're talking about like lawyers being a business in itself, and that is sometimes why many traditional lawyers are very protective of keeping things as they are, highly regulated, difficult to access, kind of elite monopoly. I think we also have to remember that, you know, obviously developing various solutions is not free either. And legal tech is going to have a cost, especially if, you know, at some point these solutions are made available free for beneficiaries. Like, people often say, you know, when something is free for you, that means that you are the product, not the product you're using. I think it's one of those things about Facebook, it's free to use, but we're actually the product making the money. And so I think it's really interesting about big data being big business, essentially, and kind of understanding where the ownership of that data comes in, and then how we can still ensure balancing those initiatives, that legal tech is still cost effective and actually seeks to kind of serve the beneficiaries that it was initially created for.
Thank you, Charlotte. And given that we've got only a couple of minutes and Susanna is already featuring in the corner of my screen, Mike, if this big data is so big business, billions, gazillions, how much actually data in all these machine-to-machine things, in all other devices that can be used as legal evidence? This is a more valuable stuff. The last minute, the last statement by you.
Gosh. Data, it's moved so fast that I can't claim any insights into it. I do know that the US Treasury has said that informally that the problem of integrating data is $1 billion problem, and that's just the old-fashioned problem of integrating different data sources, which is another thing why you need common meaning. It's what we originally built that for in finance. But I'd like to finish my thoughts by picking up there's a danger of us repeating the AI winter, the proceduralist versus connectionalist. It's now, symbolic versus statistics, but it's the same thing. They both have a use, but the real way forward is going to be an explainable AI where we take, again, formal ontologies, but not ontologies that are even about data or integrating data, but ontological representations using various levels and kinds of logic that represent real things in the world in order to be able to tag what comes out of learning neural networks with meaningful knowledge. So that's, I think, the one to watch.
Thank you. And the very last question for Alexis in the very, very last minute. Alexis, it was so easy to create open language for legal stuff. Can we ever have open data?
I think it depends on what the data is, because which sort of, I'm trying to answer two questions at once. So your question, Drago, and also Richard's questions about using sort of statistical ML. And I'm not saying that machine learning doesn't have a place in legal tech. It does. It's just not a place for most people to dabble in, because we don't own data, because most of the data is owned by the people who created them, or the people who've been holding them, since before, and sell them to lawyers and have their entire business model built upon that. So if we were to build something with sort of statistical ML as a sort of starting point, we would run out of money because we spent all our money buying data, because otherwise you wouldn't have enough data to train anything on. So I think we could have a future where I think having data is important, but then I think there's different kind of data. There's data that is fundamental data, like statutes that are codified, laws that are codified, regulations and guidelines that are codified. That's a kind of data. The language that is created, how it is written, the libraries that are created, that can be data that should be open source. But there's also sort of value-added data. What if an application was built atop of that? Or what if someone, put in their own data that they're not willing to contribute to the rest of society for whatever reason? I think that's that too. And there's also data that, you sort of want to create after using the application. Who owns that? So I think it's not an easy question to say whether there will be open data. I think that question, whether there is open data, doesn't apply to any industry, because there isn't an industry where every data that exists is open, and I'm not sure if that is even an ideal that we're even aspiring towards.
At least we know that we are not going to apply machine learning to do backtesting of legal cases and apply some reinforcement learning experiments on
I hope not. I mean, it's dangerous. People have tried that in the US. There are a couple of startups who are like, oh, that wasn't the outcome we're expecting. That's embarrassing.
They didn't give consent. This is not.
Or you have Google who mistake, gorillas and black people, and it's just odd. Yeah. And you say, why are you doing?
Okay, I know that we can go on and on, but I can see Suzanne. Suzanne, Mike, over to you. I had a brilliant panel, so many questions that I couldn't cover, but this was our best globally between Singapore and Eastern Europe, and back to you in.
Fantastic, Drago. Thank you so much for moderating such a great panel discussion. I would like to thank Mike as well, Alexis, and also Charlotte, for joining us and for sharing your expertise today with our audience. And Drago, thank you for moderating the panel so well.